As a general rule, I usually advise people not to sign it right away. Take your time, review it, see if you can negotiate your severance pay. Some employees prefer to talk to an attorney beforehand, and I always advise to talk to an attorney and see if you can negotiate or review your rights and see how much are you giving up on. So as a general matter, employers are not legally required to offer severance during layoffs, but there are certain exceptions to this rule. Some employees may be entitled to severance pay under a contract with their employer. For example, if an offer letter explicitly provides that an employee would be offered severance in the event of termination or layoffs, this provision becomes legally binding once the employee accepts an offer letter and signs it. Another exception to this rule is if an employer has a policy or practice of providing severance to its employees, the employer must provide it to you if you comply with the requirements of the policy. Basically, if everyone is offered severance upon layoffs, then you should be entitled to it as well, provided that you meet the requirements. If offered severance, so the provisions that we usually see in a severance agreement involve severance pay, meaning how much the employer is willing to pay you, continuation of health benefits of COBRA, and release. The most important one is the release of claims against an employer. An important thing to consider when signing a severance agreement is whether or not you have any potential claims against the employer, because once you sign the severance agreement, you effectively give up on those claims. The claims that you should consider whether or not you're willing to give up include discrimination claims, harassment, including hostile work environment, retaliation, wage and hour, and whistleblower protection. So make sure you talk to an attorney, confirm that you have no potential claims against your employer before you sign the severance agreement.